LAWCAM. Law Chamber of Aditya Mishra aimed at establishing a platform focused on online dispute resolution to benefit students and enhance the field of dispute resolution. With that, it gives me great pleasure to welcome Aditya Mishra sir, who will be sharing valuable insights with us today on arbitration advocacy. Over to you, sir.
Yeah, thank you so much for this introduction. I hope everyone can hear my voice. If I'm slow, just let me know. I can raise my voice. I can increase the volume. Um, can I hear something from you?
Yes, sir, you're perfect.
The participants. So the participants, if I, Daisy, if I correctly understand, that all are the, members of Taac, right? Who are participating in this competition. And they,
Yes.
okay. So I have been given this webinar to talk about the arbitration, regarding Arbitration Act, regarding why arbitration is a cornerstone of the ADR, which is widely used in infrastructure dispute, maybe in the commercial dispute, and regarding the institutional arbitration, why it is growing in India. You might have heard about the MCIA, DIAC, ICA, IIAC, and internationally SIAC, then IAC, right? Can it be interactive so it will be helpful for me if you are getting something or not?
Yes, definitely. I think the participants are encouraged to please have an interactive session. If you can also have your camera on, I think that makes more sense.
It will be good for me as well. So, because I would be sometimes I'm very fast also. So if you have lost something, you might not be able to catch up. So this is the reason I am telling you, if I'm very fast, just let me know if you're not able to understand, because it has to be interactive. Correct? I think
Yes.
Daisy is going to share the slide first.
Yes. Is it visible, sir?
I am not able to. Yeah, I just saw that. Yeah.
Is it visible to the participants as well, or do you want me to zoom in? Anything that?
Yes, ma'am, it's visible.
Okay. Sir,
Okay. So the first slide, it is written view slide resume. I am not able to see. Yeah. Can
is
you
it okay now, sir?
थोड़ा सा zoom in चाहिए मुझे?
Probably I'll make it a slide. Better now?
Yeah, for me it's good now.
Okay.
So the focus would be today regarding the practical steps from the how to prepare a notice to the arbitration under Section 21 of the Act, and regarding the response of the notice. Then if both the parties are not decided to go for the sole arbitrator, if they don't consent it, then what will happen the next stage? What is the Section 11? Why you go to the high courts for appointment of the arbitrator? Then how the arbitrator commence, arbitration commence, and what are the steps involved. I have told you regarding the notice also, response also. We would be covering the procedural order. That's very important for your competition. Why it is issued by the tribunal after consideration, by hearing the parties regarding the constitution of the tribunal, why the timeline has to be set and procedure has to be laid down. What is the statement of claim? Why the statement of defense is filed? What are the timeline of filing the SOC and SOD? Because statement of claim is called SOC and a statement of defense is called SOD. And when you file the rejoinder, it's called SOR. So these terminology you should know starting here. And what are the rules would be covering, like whether we are going to use CPC or any private rules that has to be governed through the entire tribunal. regarding the witnesses, regarding the experts, regarding the language, regarding what language has to be used in the arbitration, and what seats should be there. What is the seat of the arbitration? What are the venue of the arbitration? What would be the fee of the arbitration, and so on. So then we would be covering, I told you regarding section 11 also, appointment of the arbitrator. Then the challenge to the arbitrator is very important. Section 12, I'm going to read. I will going to tell you regarding what is the fifth and seventh schedule regarding the challenge to the arbitrator. Because once the arbitrator is appointed, you have a chance to make a challenge regarding the biasness. If he is a bias, you can move an application on section 12 of the Arbitration Act, and why it has to comply with fifth schedule and seventh schedule. We are going to discuss this also. I will be telling you the advocacy regarding your oral round, why you have to master your facts, regarding why you should know the chronology of the the statement of claim, your claim basically, what are the contractual clauses, why it is important, why you have to speak with confidence and clarity. Because you see, you need to understand, you have to frame certain issues, then you have to go for a rules, then application, and then relief. So it has to be structured form when you go for arbitration, and this is how you have to argue the matter before the court. So I would be telling you about this. I will also covering the cross question which comes from the tribunal. Sometimes in my experience, I have learned this. I have never anticipated some questions coming from the tribunal. And this is not a court proceeding. This is a private proceeding where you have ample time to see. So that is the good part. And there are certain drawbacks also. You cannot just say, okay, I will see, and, give me another date, I will come back. You have time. They will say, okay, you see the document and come back to me. So I'm going to tell you about my experience also. I will telling you regarding the focus on the relief which is sought by in your statement of claim, and why you should not make any emotional argument, because a lot of people do in the court, but it is not available in the tribunal. You cannot convince the tribunal with your emotional argument, because it is a purely contractual thing. um, I would be also covering why you should be consistent with your argument, why you should not be repeated again and again. You should repeat, sir, refer to this clause, refer to that clause. You have made certain arguments, then you have to stick to that argument. Uh, then time management is very important. How you have to going to split the argument. What are the, how you're going to phrase your arguments. So this is all I'm going to cover. And lastly, I would be sharing a template which I have shared with the team also, regarding the notice of the arbitration, what notice of the arbitration should include, and what and how the response has to be made. And the template will tell you regarding, another template is regarding the procedural order. So this is what I'm going to cover. Is it okay?
Yes, sir.
Can you
Yes.
just say yes or no, something?
Yes, sir.
Yes, sir.
Yes. So hopefully, if you think I am very fast, just let me know. If you're not able to understand, just let me know. If you can, or you can text also. यहाँ पे होता है ना उसमें text का.
Yes, the chat box option is there.
मैं chat भी खोल ले रहा हूँ in case.
Sir, in general, we'll inform you if there's something urgent which comes up in chat box. But generally, once you're done with the session, then we'll take up the questions.
Okay. So questions we can take in between or after, Daisy?
So it depends upon the speaker. Generally, we take it like at the
Because
end
see,
only.
when suppose if I start with suppose I'm going to tell you regarding the arbitration agreement. If somebody has some question regarding the arbitration agreement, then he can speak. Or even you can see the text message. You can just let me know ki we have one question regarding this, so I will make a clarity. That would be nice, no? You
Yes.
can read. You can tell me your queries.
Yes, sir.
So let's start then. Correct?
Yes.
So I hope that we have broadly understood what is arbitration. What I'm going to, today I'm going to talk about regarding the foundation of the whole process. So the most important thing today is arbitration agreement. Everybody have heard about the arbitration agreement. Yes. So arbitration agreement is defined in Section 7 of the Arbitration and Conciliation Act. And I'm going to read this part. In this part, the arbitration agreement means an agreement by the parties to submit the arbitration or certain dispute which have arisen or which may arise between them in respect of defined legal relationship. Complicated है थोड़ा, but I am going to simplify this. What Section 7 define? It is an agreement between the parties to submit their dispute to the arbitration instead of going to the court. Make sense? I hope you're getting it.
Yes, sir.
And I have a question that before that, will tell you the act also tells that it must be in writing, but writing doesn't always mean a formal signed contract. Can it be a signed contract or not? That's an issue. Or it can be exchange of letters, email, WhatsApp, or you can say WhatsApp where both the parties agree to the arbitrate. Or it can be a part of another contract usually called arbitration clause. So basically, arbitration clause shows the intention of the party to arbitrate. If the intention of the arbitration is clear, even there is no signature, it can still be valid arbitration agreement. That is the question which recently Supreme Court has held in Glenmore International versus Sri Ganesh Metals. Please note this judgment which recently came in from Supreme Court. Now, there was an issue which says there is no arbitration agreement because there was no signature. I will tell you the facts regarding this case. So there was no signed document, but it was a document which is coming from the subsequent contract. So the matter went to the High Court because they filed a civil suit. The matter went to the High Court, and High Court says, look, there is no signed document, and we can't see this is an arbitration agreement. The matter went to the division bench. They also said, okay, fine, the single judge is right. But when the matter went to the Supreme Court, then Supreme Court says we have to see the intentions to arbitrate. If there is no signature, it can still be a valid arbitration agreement. In that case, the contract was unsigned. But the parties has exchanged email and performed the contract. The court said even without signature, there was a clear consent. So arbitration clause is valid. This is something new which we have seen recently. So basically what we have to see, there must be an arbitration agreement, might not be signed formally, but in regarding your informal exchange also regarding somewhere it shows that we are going to execute the arbitration, and that arbitration has to be maybe it is not signed, but it has a valid arbitration clause. That contract has a valid arbitration clause, correct? Yes or no?
Yes, sir.
1 second. Can you give me a second? Yeah. So what slide is going on? Arbitration is one of the method resolving a dispute. So I think we have done. Can you put some arbitration agreement slide?
So let me know which one to, like the first one.
Come to second.
Second one, this one, arbitration advocacy.
Institutional. इसके भी नीचे आना था. I think Arbitration advocacy, institutional arbitration, नीचे. Advantage of institutional arbitration. उसके नीचे आना. Can you come down?
This one?
I can't see. I can only see arbitration is one of the method of resolving dispute. Or should I share from my end?
Sir, I think आप फिर कर लीजिए because I don't know why it's not happening.
Give me a second. So I was talking about regarding the recent judgment of Supreme Court, right?
Yes.
The recent judgment of Supreme Court says that the contract was unsigned, but the parties through the emails, and WhatsApp, whatever it may be, they shows a clear intention that there was a valid arbitration clause, and the court said even without the signature, there was a clear consent, so arbitration clause is valid. So this shows that substance is more important than the form, you can say, correct? So even though it is not signed, but your uh, uh, intentions to arbitrate is already there. So that is important in this judgment. So I'm going to cover what are the essentials of valid arbitration. Correct? It has to be in a written form. It should be flexible. It can be in emails, letter exchange of documents. Even electronic contracts are valid now. So it has to be in written form. There must be a clear intention to arbitrate, because the word must clearly shows that the party wants to resolve the dispute. It cannot be in the ambiguity. If you see my slide, there should be an intention, correct? The word must be clearly show the party wants to resolve the dispute by arbitration. If the clause says the parties may try to arbitration or parties will consider arbitration, is it binding or not? According to me, it is not binding, because Supreme Court has said clearly in numerous judgment, the clause can spoke about more negotiations and mutual settlement, but it does not show a binding intentions to arbitrate. The court said unless there is an intention are clear and mandatory, it is not an arbitration clause, right? So we have to talk about the scope of the dispute. The agreement should define which dispute has to be covered. Usually the word is all dispute arising out of in connection with the contract. So you can see in any of the contract, I have covered the FITIC contract, I have covered the MEA contract, I have covered the CPW contract, I have covered the this railway contracts, the railway dispute, and they all use this kind of word. This if regarding they are very particular. All the dispute arising out of in connection with the contract. So this is a wide enough to cover both contractual and related dispute. So they want to cover this. That's the reason they draft in a way that regarding the project, any dispute arise, every dispute shall be referred to the arbitration. So the arbitration and that it has to be referred to the arbitrator depending on. So there should be a binding on the parties. The agreement must be binding equally both sides of the parties. Arbitration is based on the mutual consent, and party cannot unilaterally impose it on other. So once there is an agreed, both parties are bound and neither can approach the civil court except for the limited interim and supporter relief. So if I can just stop sharing 1 second. So my video is off. Yes. One second. So basically, can we move to the court if we have the arbitration agreement or not? That's a point, correct? So there are section 8 also. There are section 9 also. suppose if you want to constitute an arbitral tribunal and the other party is not agreeable to your consent of the arbitrator, so the option is left that we can move to court in section 11 and we can go for appointment of the arbitrator. That is one thing. And suppose before the formation of the tribunal, if we have some urgent interim relief, so there we can go to the court in section 9. Recently, what we have, I had an experience in regarding, there was an arbitral award given to some contractor and we were the lenders. And this example will make you understand why it is important, why section 9 is important, and sometimes why you have other remedies as well if you want to secure the money which has been already given in a dispute regarding consortium of bank where they have lent some money for the construction of the project. This is very important. And this example might help you to understand section 9 and section 8 also. So section 9 provides the interim relief. And in this case, what happened? The bank approached me and said, look, we have a debt due regarding the claim, which we have already given to the construction, agencies, construction contractors. And this clause says upon termination, they have to deposit the money. Now, this is a concession agreement. And what we have done is that we have given the opinion that, look, now if you want to have a dispute, you have to first file a section 9. And in other matter where already you have an arbitral award, what you can do, you can invoke section 226 of the Constitution, because there the dispute has been solved and debt due has been decided. In other matter, when the dispute was already there, then what we have done, we have moved a section 9 application. We said we are going to apply for an arbitration, and in meanwhile, please secure my interim, please secure my payment which we have given, because as per the contract they are supposed to deposit into the escrow account, because we have an escrow account and there is a dispute, so you have to deposit. So there section 9 was applicable, and here section here's 226 of the arbitration, so 226 of the Constitution is applicable. So this is a difference. If hopefully I have made this clear or not, I don't know whether you are able to understand it. Can you just give me some hi hello regarding, are you getting it or not? ज्यादा हो रहा है तो मैं इसको थोड़ा और सिंप्लीफाई कर सकता हूँ.
No, sir, it's perfectly fine, I guess.
Fine?
Yes, sir.
Okay. So this is regarding the arbitration agreement. Arbitration agreement should be binding on the parties. It clearly says scope of dispute. Maybe it's signed or not signed, but intention has to be clear. Recently, what Supreme Court has said. So once you start drafting the arbitration clause for your competition, please understand you have to record the scope of dispute. It should include the scope of dispute. It says wording will start like this: all the dispute arising out in connection under this contract will be referred for an arbitration. If you write may or may not, it would not be a binding, or it cannot be include all the scope. Correct? So there are certain case laws also, which one of the case laws I've told you, Glencore International, which recently came and Supreme Court held regarding the intention. But the point is, why? One more thing. The important thing regarding the arbitration agreement, why it is become very critical, because I have told you, it cannot be a poorly drafted arbitration agreement, because there it leaves the scope of ambiguity. So it cannot be ambiguous, because then if you go to section 11, suppose, let me tell you this, even you have a big contract, and I have experienced this, worth of 100 of crores, a dispute arises, and if you invoke the arbitration, but then you realize that clause is vague and it doesn't mention the seat, doesn't mention the number of arbitrators, because you have to mention, you can appoint a nominee arbitrator, you can appoint, the other party can also appoint their nominee arbitrator, and both the nominee arbitrator will going to appoint as presiding arbitrator, and it is not clearly mentioned there. Then it it is not a, it could be a poorly drafted, it can be said a poorly drafted arbitration agreement. So what happened in the court, one party will say, no, I don't agree with the arbitrator. The other says the clause is not binding. What happens? You end up in the court under Section 11 fighting to just get a tribunal appointed. And it will take months, sometimes year, because ultimately Section 11, then you will file the appeal, then you will go to Supreme Court. So a lot of times are wasted before the actual arbitration begins. So therefore, for you always, as a young law students and the lawyers going to be, so please understand, if you are into commercial disputes, if you want to do arbitration, you need to know why the arbitration agreement is critical. So a good arbitration agreement is like a strong foundation. If a foundation is shaky, the whole process will collapse. So basically, that's the reason why arbitration, agreement is very critical, very important, and it has to be good drafted arbitration agreement. Whether it is signed or not, that has been held recently by Supreme Court. So don't go for that. Intention should be clear. So I can tell you the tips regarding the practical tips of drafting. Also, I told you regarding, you always specify the seat of the arbitration. You mentioned the governing laws are very important. In fact, for international contracts, specify whether Indian contract or foreign law governs the contract for the arbitration. Correct. So mention the governing law. You have to mention the number of arbitrators. How many arbitrators? There should be a sole arbitrator, or maybe there are nominee arbitrator. There might be, how you're going to decide. There would be a 5 arbitrators also. There can be 7 also. There can be 9 also. But that has to be clearly mentioned in that agreement. You have to mention it would be an institutional arbitration or it would be an ad hoc arbitration. So I'm going to speak on the institutional as well as the ad hoc arbitration. In India, we have this system of ad hoc arbitration, which is more prevalent. So in ad hoc arbitration, the parties says, okay, fine. If there is any dispute, we will appoint you nominee arbitrator. We'll set up, a place where we will appoint like Supreme Court judge who is going to decide uh, the dispute between the parties. In the institutional arbitration, which is little bit different from the ad hoc arbitration, where already you can decide your arbitrator, fees is fixed. So that is something which I'm going to speak later. Now, the difference between ad hoc and, so this, the tips regarding drafting of the arbitration agreement is required, clearly mentioning that it has to be institution or ad hoc. The language has to be crystal clear. I've seen the cross-border disputes. I've seen the contracts where language proceeding has to be clearly recorded. In what language the arbitration has to be conducted, and also, yeah, please don't mix arbitration with litigation clauses. That's what is very important. For example, don't say party shall go to the court. Don't use the word shall go to the court, but may also arbitrate. You can't use this. This create a confusion. So it has to be crystal clear that if there is a dispute, we are going to arbitrate as per the arbitration agreement executed between the parties. So these are the tips. I can also tell you regarding the best clause in this how to draft a arbitration agreement. So all the dispute, we can say that, and this is what I have written also, just to share with you. All the dispute arising out or in connection with the contract shall be finally resolved by the arbitration under the rules of, now here you can say GRF rules, you can say SIAC rules, you can say LIAC rules. These rules you can incorporate. So this is how you have to draft. The seat of the arbitration shall be in New Delhi, or shall be Singapore, or shall be whatever place you want to have. That has to be clearly mentioned in that particular clause. The tribunal shall consist of 3 arbitrators. The language shall be in English. This is how you have to do. You have to use this word shall. This is a precise, leave no scope of confusion and ensure smooth administration of the institution. So this is very important for your competition and for your coming litigation practice also. So this is regarding the arbitration agreement. I hope I have made this clear.
Absolutely, sir.
Okay. Now, the next would be that I would be covering regarding Section 8. Section 8 is very important to understand. The wordings of the section is power to refer the parties to an arbitration where there is an arbitration agreement. Now, this is very important section. And Supreme Court has held a number of times that the existence of the arbitration agreement should be upheld if the intention is clear. Minor defect in word will not make it invalid. So suppose in this matter, in this case, Glenmore case, if I can say, parties may have opted for Section 11 application. Look, boss, there is no arbitration agreement, and they are going to commence the arbitration. So this is how the Section 8 is important. And we can say to the court, look, there is a valid arbitration clause. Therefore, civil court proceeding will not be initiated. So we can make this argument also. This is why Section 8 is there. Now, so this is all regarding the Section 8. I think I can also say regarding the arbitration agreement must exist and be valid. If it is vaguely or broadly drafted, the court may refuse to intervene, which might have happened in single judge, and it has been to the division bench, and then the Supreme Court finally decided in that case. So again, the strength of the arbitration clause decide whether you can push the dispute into arbitration or not. So this is why Section 8, Section 9, Section 8 and Section 7 is important. So what we are going to cover next regarding domestic arbitration, the types of arbitration, we can start. Can you see the slide? 1 second. So I will be speaking on the domestic arbitration and international commercial arbitration, just to give a brief regarding what kind of arbitration take place in India. So you need to understand this. There is a phrase called domestic arbitration. There is a phrase called purely domestic arbitration. There's a you can call international arbitration, international commercial arbitration. So I am going to cover the domestic arbitration first. And this is what happened in India. The first and simplest type of arbitration is domestic arbitration. This happens because when both the parties are Indian and the governing law of the arbitration would be the Indian law. So in domestic arbitration, both the parties are to be Indian parties, right? And clearly mentioned that governing law of the arbitration would be in the Indian law. So, for example, if I can tell you regarding, I can share my example regarding Indian construction company is there, and there is an Indian developer signed a contract to build an highway, right? Now, they include an arbitration clause saying dispute will be resolved under Arbitration and Conciliation Act 1996 with the seat of arbitration in Delhi. So if the dispute arises, it would be domestic arbitration. Everything, parties, law, seats in India, domestic arbitration is the most common in India. And you see, I've seen infrastructure projects, roads, bridges, power plants, and supply contracts between the Indian company, service agreement, franchisee agreement, even the employment contracts. So these awards in an arbitration, in a domestic arbitration is enforceable in India, because it is domestic arbitration like a degree of a civil court under Section 36 of the Act. Section 36 of the Act talks about the enforcement of the arbitral award. But I mean, I will be speaking someday regarding the Section 34, which is the challenge to the award. That is the broader ground regarding the patent illegality and perversity, which we are not going to cover today, but just give you a brief idea that a domestic award has two additional grounds to challenge in the court. That is patent illegality and perversity, which came in 2015 amendment. And certain clarifications also came later regarding Sanyong judgment and DDA versus associate builder. And we are still struggling when I argue matter regarding domestic arbitration and international commercial arbitration, because once you are in international commercial arbitration, so these two grounds are not applicable to us. So patent illegality and perversity is not applicable in ICA, and when we are not in ICA, then we have to argue patent illegality and perversity. And there is a very thin line regarding how to convince the court that what the grounds we are taking in ICA, now it is falling under patent illegality. So sometimes it is a tough job, and hopefully some clarity will come. Recently, a very good judgment of Supreme Court came, written by Justice Manoj Mishra, and he has given a lot of clarity regarding the patent illegality perversity ground, which can be taken in the domestic arbitration, and what grounds you can take in international commercial arbitration. So that is also we have learned recently. So I can tell you regarding the international commercial arbitration, if you have the act with you, just wanted to show you regarding the Section 2 definition, which F, 2F, regarding international commercial arbitration. And allow me to read this, that it means an arbitration relating to the dispute arising of a legal relationship, whether contractual or not, considered as a commercial under the law in force in India, where at least one of the parties is, that's important, one individual who is a national of or habitual residing in any country other than India. So this is quite clear. One of the parties is an outside party. It has been incorporated outside, or national or habitual resident of the other country. Second, a body corporate, which is incorporated in any other country other than India. So if a country which is incorporated, suppose for example in UK, and you have and now that company have a contract with India, so these kind of arbitration will cover under international commercial arbitration seated in India. That's very important. International commercial arbitration seated in India, we can say. So, and a third one is association or body of individual whose central management and control is exercised in any other country other than India. You have a company, but the management is outside, controls is outside. That also a criteria which falls under international commercial arbitration. And the government of foreign countries, so and so forth. So this is an important line which I'm going to say. So I'm just going to tell you regarding 2(1)(f) of the arbitration, talks about the ICA. And a party is considered foreign if it's contracted outside the India, management is outside the India, majority ownership is outside the India. For example, suppose a Singapore company enters into a joint venture. They agree that dispute shall be resolved seated in Mumbai. So this is an international commercial arbitration seated in India. This is what I was saying. Suppose a company which is incorporated in Singapore and came to India, and their agreement says that if any dispute arises, again, the arbitration agreement clearly says the seat of arbitration will be in India. So one party is outside, other party is India. So this is called international commercial arbitration, governed by Part 1. See the act, read it, you will understand what is Part 1. You can just go to the index, you will understand what is Part 1. So I'm not going to talk much about that. Part 2, Part 1, some other day, because it will be a long, webinar regarding if I talk about the Part 1, Part 2, what is foreign award, what is international commercial arbitration, domestic arbitration. So I'm going to keep it very short. So just because I wanted to tell you regarding people have problem understanding what is the international commercial arbitration, what is domestic arbitration. So that's why I told you. So now ad hoc and institutional arbitration. Can you put the slide? We are dizzy.
So should I share?
Yeah, please share.
Share it. Uh, is the screen visible?
Yes, ma'am.
So which slide do you want me to come to?
No, there is a advantage. नीचे आना चाहिए ना, please. So you can say institutional arbitration. I can speak on this only. So institutional arbitration. I hope now you have heard a lot of institutional arbitration names in India as well as outside India. So advantages of institutional arbitration: neutral rules, panel of arbiter appointed on the tribunal would be neutral. This reduces the conflict of appointment of arbitrator and challenge. So these why this is very important these days, because the challenge to the institutional arbitration would be the minimal. The what can be enforced. We cannot say, this arbitrator, the sole arbitrator was biased. They have certain rules regarding the institutional arbitration. That's why now we have seen why institutional arbitration has come in force, and why it is prevalent over the ad hoc arbitration. Because institutional arbitration, the good part is regarding the administration process. Um, so I tell you something. There was a case in Supreme Court in international commercial arbitration where the Supreme Court uh, directed the parties to appear before Mumbai International Commercial Arbitration. Now there was an issue which sought some clarification in Supreme Court itself, that we said, in our contract, we have not mentioned we will go for the institutional commercial arbitration, and institutional arbitration, you can say, and this is the ICA, and we don't want to give any administrative fees to that institution. So Bombay, Mumbai में एक है, Mumbai, what is the exact name of that? Mumbai MICA, right? Mumbai Center for International आर्बिट्रेशन. जैसे हमारे यहाँ DIAC है, दिल्ली इंटरनेशनल कमर्शियल आर्बिट्रेशन है, एक हैदराबाद में है, दैट्स हैदराबाद. So there we have the Supreme Court has directed. So I appeared in that matter and I said, and there was an ex-CGI who was appointed as a sole arbitrator. Now there was a dispute and we said we have not opted for institutional arbitration. But later, because for a simple reason, they are going to charge the administrative fees, and that was a hefty amount. So we said we are not willing to go for institutional arbitration, and we go for a ad hoc arbitration. Why are ad hoc arbitration? Because today I tell you, after the COVID, what we are using, we are using all the ad hoc arbitration online through Zoom meeting. The arbitrator is sitting somewhere in Bangalore. We are in Delhi somewhere. Someone is sitting in Calcutta. So in these circumstances, we use the Zoom meeting, and we don't have any administrative charges because for flight charges. Because once you see the procedural order, when I will come to it, um, the arbitrators usually say that, we want to have the business class, we want to travel for so and so car, we have to, have a 2 hours, 3 hours meeting in the 5 star. So that cost has become very minimal after once we have started this online arbitration. So what you can say, uh, online dispute resolution, we can say, because you are using online, that we can say that ADR, ODR, the concepts are very trending these days. So now we are using this online dispute resolution and ad hoc. So sometimes institutional arbitrations are good. Sometimes parties don't refer to it. Now I am not sure what is going to happen in future, but right now the prevalent is the ad hoc arbitration, which I can say. And if you have Singapore International Commercial Arbitration rules applicable here, and the way they conduct the proceeding there, where Indian party, I have seen the Indian party incorporated in their arbitration agreement, that's if there is any dispute, we will go to the Singapore International SICA bolte hain, in the Singapore International. What is the exact name? Somebody can help me?
SIAC, I believe so.
Huh. So we can go directly to to Singapore. So this is what regarding the so now the advantage would be, in my opinion, because the kind of experience I have, I think today itself institutional arbitrations is going on because of the neutral rules, the panel of arbitrator. We have choices to appoint a panel of arbitrator rather going into section 11 between to the court, and section 11 they will decide some there is some message. Okay, this is not for me. So in section 11, what suppose without the consent of the party, if at all the party gives consent, the High Court appoint a sole arbitrator, and later you found that it is not a good way to approach the court. So institutional arbitration, suppose you are a technical dispute, you can appoint a engineer as a dispute resolution person. You can appoint as an arbitrator to present the dispute. So you can see the profile. You are free to appoint someone based on the claim, and that is why the institutional arbitrations are important. They have the faster appointment mechanism. You just have to log on the website and fill your dispute. You can see the what kind of profile they have, and enforceability and reputation is also very good, which I said about the Singapore. So this is all regarding the advantage of institutional arbitration. So can we go to the second slide regarding pre-arbitral proceeding, amicably resolution, settlement? What is this? Anybody can help me? So pre-arbitral proceeding is very important. Pre-arbitral proceeding, if you've seen in your in the contract, which says alternative remedy is mandatory prior to the arbitration proceeding, where it provide where it is what is written. Can you just read? Where it is provided in the arbitration agreement. Let me tell you frankly, the arbitration agreement talks about the dispute resolution process. In India, it is called dispute resolution process. Outside, we have DRB boards also. In Australia, I was going to a judgment which talks about the DRB, dispute resolution board. So they have the board. First, you have a problem, you go to the board. Then you go for arbitration. So what remedies we have to exhaust, that now dispute is here. I have written a dispute to the other party. Now other party will see what are the claims. They will say, okay, if you want, then we can sit together, we can resolve the dispute. And now the mediation is also coming. I have seen the contracts now, they are putting the mediation also. So initially it was like, if you see the FIDIC contract also, if you see the MEA contract also, everywhere there are three steps to go for arbitration. Arbitration is the last resort. First, they try to solve the problem sitting on the table, which is very important now. And I think if we can solve the problem on the table itself, there's no requirement for the arbitration. Mediation is very important, but the problem is the training regarding the mediators. Now, I have seen that, a lot of trainings are going on. If you have a good mediator, then mediation can resolve the dispute. And it helps the party not to go for the arbitration. So the procedure, the steps would be in the contract. First, you decide that dispute, refer the dispute to the other party. Then subsequently, there will be a notice that, look, you have raised a dispute. As per the contract, I want to invoke that clause for amicable settlement. If the amicable settlement is not happening, then go for a mediation. If at all you have that, if you have that clause incorporated in your contract, and once the mediation is failed, the last resort would be the arbitration. Then when you decide that you are going for an arbitration, then comes Section 21 notice. What Section 21 notice talks about? That now, since all the pre-arbitral proceeding has been failed, so now I'm going to give you a notice under Section 21 for commencement of arbitration proceedings. Correct? So can we go to the next slide? Yes. थोड़ा सा इसको आप एक्सपैंड कर दीजिए.
So is it fine now?
Yeah, it's good. So either party can make the notice to the other party formally initiate the arbitration proceeding under Section 21 of the Act. The notice is requested by one party to refer to the dispute to the arbitration proceeding. Now, I'm going to explain it rather than reading. It is for you to read. So, what Section 21 talks about it, that let us move for the arbitration now. The very practical question is, when does the arbitration actually begins? The arbitration begins with this notice. Once the pre-arbitral proceeding has failed, now you are going to invoke Section 21 of the Arbitration Act and say that we will going to arbitrate. But when does the process formally start? Is as per the notice of the section. So the legal start point of the arbitration, I can say, is Section 21, which clearly says arbitration proceeding commence on the date when the respondent received the notice of the arbitration from the claimant. So there would be a claimant, there would be a respondent, or you can say a non-claimant. So Section 21 says that arbitration proceeding commenced on the date when the respondent means who are the non-claimant, who has received the notice of the arbitration from the claimant. So that is a very short provision, but very powerful in the arbitration. This means if I am the party and you are party B, we have a dispute, and in our contract, the arbitration only starts when I send a notice of an arbitration and you actually receive it. So now when I draft it, I think so the problem is, ऐसा नहीं हो सकता कि you have to think that I'm going to draft it. You have to call the lawyers, you have to sit with them, you have to draft formal Section 21 notice, you have to send through them, and it has to be properly received by the other party. Therefore, the section 21 is very important. So, and also the limitation starts with section 21. In India, yeah, first limitation in India, limitation is a strict concept, for a formal contract, usually 3 years from the date of the action. So, yes, any questions? I thought somebody
No,
wants
sir, that
to.
was, I believe, a mistake. We can carry.
Okay, so maybe. So section 21 is very important. I just, 1 second, I just open my commencement of the arbitration proceeding, unless otherwise agreed by the parties. Arbitration proceeding in respect of the particular dispute commence on the date on which the request for the dispute to be referred to the arbitration is received by the respondent. Daisy, can you just share the template of the section 21 so that I will be able to
Yes, sir. I'll just. So it's shared by Manya on the screen.
Okay, थोड़ा सा इसको, can everybody see that?
Yes, sir.
That's fine. That's fine. That's fine. So the section number notice. This is very important, and you should use this template for future also, for the competition also, because it includes everything. Now, what must a notice contain? So what exactly do we put in the notice for the arbitration? This act itself does not give the detailed format to, but the practice and the case laws which we have seen and the guidance which we have got from the court itself, a good notice should be drafted under certain heads which I have given the templates right now, which is on your screen. It's talk about the name, address of the parties, reference to the contract, description of dispute, what are the reliefs sought, because you have to include the party's name, addresses, who is sending, who is receiving. That's very important for a valid arbitration. It has to be received by the parties, the non-claimant. The reference to the contract has to be mentioned. You have to mention the agreement, details of the agreement, the arbitration clause, when it was signed, what purpose it was signed, brief description of the dispute because of this contract executed, so we have a dispute. You don't have to give the full statement of claim, but at least you should summarize what exactly the dispute is all about, and what relief you are seeking through the arbitration when you're invoking section 21. And then again, the relief should not be in full details, but the relief like damages, payment, performance, these kind of things you can include in the relief. And you can also propose your arbitrator. For example, we can say that we propose X for as a sole arbitrator, or we propose to appoint one arbitrator in our side, and you may appoint your nominee arbitrator. Has to be written. You have to write the seat and governing laws. If not fixed, then this will help you to avoid later dispute. You have to include all this. The notice will be complete and difficult to challenge by the other party. So some examples I can also tell you. So suppose there is a company who supply machine. So this would be called a supply contract to company B, which is under the contract, which you can say the contract has an arbitration clause saying that dispute shall be referred to the Arbitration Act, and the seat of arbitration would be in Delhi, and there would be a sole arbitrator, and company fails to pay so and so. The company A, you can say you have to wait to send the reminders, but no payment has been received. So what I'm trying to tell you is why section 11 is important. How come section 11 come into the picture when the notice does not include each and everything? So you have to keep in your mind while drafting the section 21 notice, it includes all the things which is given in the template so as to have a valid section 21 notice which cannot be challenged in the court. If these things are not there, the other party, if you say that you have written only that this is a dispute, I have appointed the sole arbitrator. Suppose the sole arbitrator has to be appointed mutually, and you have said that you have appointed a sole arbitrator. This can be challenged in the court. So if you have a nominee arbitrator concept, you say I have a nominee arbitrator, and you have to include all other details regarding the dispute. Then it has to be then it will be a valid arbitration notice, which cannot be challenged. So just give them 30 days time after giving the 21 notice, that if you don't respond to this, we will approach the Delhi High Court under section 11. This would be called a proper notice. Now suppose there should be a response to it also. If there is no response, and then you can go to the section 11 in 30 days, but I want to share the response to the section 21 notice also, which I request Daisy to share it.
It's in the same document, Manya, if you can go down in this Word document. Yes.
Yeah, so it is a response to the notice of the arbitration. So this is the letterhead, we can say. We acknowledge the receipt of your notice of the arbitration dated so and so, issued by section 21 of Arbitration and Conciliation Act. I'm just reading this just to make you understand. So we confirm the dispute has arisen under the contract dated so and so. We agree to refer the dispute to the arbitration in terms of clause so and so. We consent to the appointment of arbitrator, justice, retired high court, Supreme Court, sole arbitrator, whatever it may be. If the clause talks about 3 members, okay, we further agree that the seat of arbitration, because it is all written in the contract, and the proceeding shall be concluded in accordance with the provision of the Act. And also, if you have any objection, if you're disputing, you can write without prejudice to our right and contention. This word is very important in contract. In any commercial dispute, without prejudice to our rights and contention, we record the following objection. The alleged claims are so and so barred by limitation, non-arbitrable, outside the scope of arbitration clause. So this is what you are making your objection, that whatever claims you have filed, it is barred by limitation. So who is going to decide these objection? Who is going to decide? Can we decide it in section 11, and or can it be decided by the arbitrator itself? That is something which I will tell you now. Also, uh, then the proposed arbitrator does not satisfy the independence and impartiality so and so under section 12 and 5th schedule. I'm going to speak on this, very important. Then we accordingly do not consent the appointment of instead of nominee. So this is how you're reserving your right. So in response, these are the templates, which is very important. First, you accept that we have a dispute, fine. We have a contract, fine. We refer to the dispute to the arbitration in terms of the clause so and so, fine. We consent to the arbitration, but we have the objections, and objections are without prejudice to our rights and contention. We record the following objection, which is the other thing. Now, can you just stop the sharing this? My video is off. Okay. So after this notice, suppose if the other party has made certain objection and you have to go for the section 11 file, section 11 petition. Section 11 is something which I will read for you. Appointment of arbitrator. So if the procedure is failed, if something is not happening with the consent of the parties, you have a right to approach the High Court in domestic arbitration, and in the international commercial arbitration, you can only approach to the Supreme Court of India. Please make a note on it. People do confused that in ICA they can approach to the Delhi High Court. No, or Calcutta High Court or Bombay High Court. The practical experience I'm telling you, because this mistakes was done, by a lot of people. They have moved Section 11 petition in Delhi High Court in ICA, which is not possible. So if there is a dispute in ICA, please note down Section 11 is maintainable in Supreme Court of India, and when the other domestic arbitration, the concerned High Court has a jurisdiction on Section 11 of the Act. So that's important point which you need to note in this Arbitration Act for your in future when you're going to deal with kind of ICA dispute. So you must know. So now the situation is this, that 21 notice has been objected. The consent has not been provided by the other party. Now you have to go to the section 11. You have filed, one party has filed a section 11. Now section 11 is filed. Initially, I also get confused sometime when I was young student and I was learning the arbitration, that there was a conflicting judgments. One side they say that, look, I'm going to see that dispute. What are the dispute you have? So initially the court says, I have the jurisdiction to see whether the dispute is arbitrable or not. Now, recently what we have seen, that there is a judgment which says, look, we are sitting in the administrative capacity and we are here to see the valid arbitration clause. That is a responsibility of the court under Section 11 of the Act. So therefore, according to me, there is the court has to see whether there is a valid arbitration clause or not, and refer the matter to the arbitrator. Where you have a provision under the Act, you can make the challenge before that. Because recently I have seen High Court normally are not going to intervene when you make a suggestion that these disputes are not arbitrable. So they say if these issue you can raise before the tribunal, and tribunal is fully equipped to resolve the dispute. And suppose if the tribunal agreed that these dispute can be arbitrable, still you have a ground to challenge before the Section 34 of that. So this is also very important. So what is the next? So this is how the Section 11 application is filed, maintainable in domestic arbitration in the High Court, in international commercial arbitration in Supreme Court, and they are going to see the valid arbitration clause. Therefore, the arbitration clause has to be drafted very well in the contract. Then you have to draft a Section 21 notice very well, like the template which I have shared with you. There should be a response to it. If you're non-claimant, that has to be in accordance to the template, because why I'm sharing this template, because these things are not given in the Arbitration Act. And these things I can tell you regarding the experiences which a lawyer have during while doing the arbitration trial, especially going from courts in Section 11, filing Section 9, Section 34, and Supreme Court. So these are the experience which I have shared with you. So now I think we can go. Section 11 is completed. We can go the first procedural order. Can you put the slide, please?
Do we need the slides?
Yes, right.
Achha, before that, one more thing, because Section 12 is very important, challenge to the arbitrator. So now just quickly, I will share with you. So once the arbitrator is appointed, if you can't blindly trust the arbitrator, so the law recognizes that arbitrator is just like a judge and must be independent and impartial. This is what the judge said. But Section 12, read with the fifth schedule. If you have the act, see the fifth schedule and seventh schedule lays down the rules of conflict of interest. So fifth schedule grounds of doubt and seventh schedule is the ineligibility of the arbitrator. So that too is very important when you read Section 12 regarding the independent and impartial arbitrator, because that he has to give declaration if some appointment has been done by the court, or the appointment has been you have appointed as per the contract, or your nominee arbitrator has appointed by you also, and the nominee arbitrators have appointed the presiding arbitrator. Everyone has to give declaration under the schedule, and they have to pass the test of grounds for doubts, ineligibility. So you have to just read fifth schedule and seventh schedule, which is very important. And that's the challenge procedure which is given in Section 12. If the parties believe that the arbitrator is biased, they must challenge within 15 days of becoming aware of this issue. That's very important. You have to show how you are becoming aware of the biasness. The challenge is prescribed and decided by the tribunal itself. The if rejected, the party may wait until the award is passed and they can challenge in Section 34. So if you see, the point is, if the award is passed, and if you know that arbitrator is biased, and you have not take a plea under Section 12 of the Arbitration Act, you cannot challenge at the time of Section 34. In Section 34, you have to show from the award itself that, look, we have taken a plea under Section 12. He was biased. We approached, we filed an application. Application was rejected, rightly, wrongly. That is not your concern. Your concern should be you can make a ground in Section 34. So please note this. Now, what we are going to do next? Procedural order. Yes. So now appointment has been done. Arbitral tribunal has been formed. So we have come to the stage where arbitral tribunal is formed and the first meeting is going to place. So now you have been given the notice that the tribunal has given you to appear before the tribunal on so and so date. So we have reached to that stage. So what happened that day? So we, claimant and non-claimant, sit in the room the first day, or suppose in ODR concept, we say online dispute resolution, then we have the Zoom meeting or a Cisco, whatever it may be. So parties will set the timeline procedure, which is called the first procedural order. Why, what and why it is important? After the reference of the dispute to the arbitral appointment, the arbitrator shall issue a procedural order on the date fixed. So he is going to decide the date. Now, procedural order issued would mention the details of the arbitrator, parties in dispute, details of the advocate representing the respective parties, direction and ruling of the tribunal. So what is the first and most important part of the timetable? The tribunal fix when the claimant shall file the statement of claim, when the respondent will file the statement of defense, when the counterclaim can be filed, when rejoinder can be filed, and rejoinder or replication you can say, but we call it rejoinder, will be filed, will be permitted. The timeline will be set, decided. I think the template will be displayed later. You can see, and we can say that claimant is to file a SOC within 6 months. A respondent filed a statement of defense. So statement of defense is called SOD. Counterclaim 8 weeks thereafter. Claimant can file a rejoinder thereafter, and then if you have any discovery application. Anybody know about a discovery and document production application? This is something which you will come to know later in the practice procedure. But there are certain applications which is very important just to understand on what basis the claimant has made the claim. Some documents claimant want to know from the respondent, he is not getting in, in the support of the document from the non-claimants. He has a right to move in an application. So the timeline would be decided. They will say that you can, if you want to some discovery application, if you want some document production, you can file an application. The application would be filed subsequently. Then if you have any witness expert, then you can have that. So the order list out details everything: hearing dates, language, confidentiality clause, what is the procedure of order, why. So if you see the language of the procedure order, you will come to understand that the way it is written, the hearing dates, everything is fixed. So can you just display the template, please? No, not the.
Sir, which one?
The another document that Mama shared.
So this is the notice template. No, this is not the one.
Sir, which one? In
Procedure
the
order.
PPT?
No, procedure order. Procedure order ka template I have sent to
I'm
you.
sharing.
Briefly, I will tell you regarding the procedure order, which is very important. And you can use it in your competition as well.
Yes, sir. Technically, sir, the procedural order we'll be releasing from the side of organizing committee, but they should definitely know what procedural order is and how, what content does it has.
So this is how it's look like. The first in the matter of arbitration between claimant's name, respondent name, date, and it is written like this: procedure order number 1. So this is not, you can see, this is not something which you see in every arbitration, but normally who are the well-trained arbitrators, the retired Supreme Court justice, because we have dealt arbitration, we have dealt this kind of thing before them. So from there, these templates are there. So the constitution of tribunal will be there. They will write that the above matter was listed before the tribunal is in the above matter has been duly constituted pursuant to the Arbitration Act. You can write section 11 reference also. They can also write they have moved section 11 petition, and by the court order justice so and so has been appointed. So ये तो constitution हो गया. Next, applicable law and seat. So applicable law would be Arbitration Act. Seat is New Delhi. Language should be in English. You can come down. The clauses you can see. Timeline and proceeding is very important. I told you regarding the statement of claim, supporting document. So there would be a specific timeline, then statement of defense, counterclaim. Read section 23 for that regarding counterclaim also. Regarding statement of defense, rejoinder, rejoinder to the counterclaim, document protection. Then parties 6 come to 7, witness and expert. Hearing, when the hearing will be start. Framing of issues. I think framing of issues I have left somewhere, but time frame in the terms section 29A, the award shall be rendered within 12 months of the completion of the pleadings. Then you can extend the 6 months with the consent of the parties. Then if not, you can approach to High Court for interim application. If you want to move any interim application under section 17, what time you can file that same? What would be the cost of the arbitration? Recently, there is an amendment which says if the claim is allowed, the non-claimant has to bear all the cost of the arbitration. Then communication by the tribunal and other procedural order. So there are certain procedural order after that which also talks about certain things, but that would be we are referring to. We will cover in some other day because it will be too long. So, but the last thing which I want to tell you regarding which is going to help you is regarding the advocacy skill. I can tell you regarding the tips, certain tips in very short, just to make you help you in the competition. You you should know, if you have drafted, you are the master of the facts. You should know the chronology of the event. You know the contract clause. So the very first rule is know your case inside out. Arbitrator can immediately sense the lawyer that he is making some excuses through the papers and some answers. If you are master of the fact, if he asks where is this clause, you should be ready with that particular page. You should be ready with that particular reference of the contract. You should ready with the communication which you wanted to refer. So you have to read everything. You have to make notes of everything. You cannot just because in the court you have time, but if you are going on into the pages, it will not help you in the competition as well as in the tribunal, because they don't have time. And it's in commercial contracts, commercial arbitration is very expensive, and clients also watch that my lawyer is not able to understand what the arbitrator is going to say. So you have to make happy to the arbitrator as well as your clients also. On a commercial part, on a lighter note, I'm saying this, but this happens in the tribunal. So you have to structure your argument, identify the issue, because issues are very important. The issues which are framed, you have to make your argument around the issues. Then rules of the law, the contract rules or any other rules which is applicable for the how the arbitration tribunal is working on it. Then applications, if any you have, then the conclusion. So these things are very important to uh, do the arbitration uh, in a good way. So these are the things. And if you have any doubts, if you have any clarification, if you want me to uh, give you any tips further, just let me know. I know it's thoda bada ho gaya hai. When it's come to arbitration, I cannot stop myself because I want to give all things experience I have. So, but later we will do it. I hope another round will be, organized by Daisy. So I would be helping you in this.
Definitely, so we will be having another workshop in the first week of October where we'll be having the details on arbitral award writing, because
Yes,
then
yes,
subsequently we'll be entering that stage.
yes, yes,
So
yes.
far, sir, thank you. Anyone who has any question, they may raise their hand. Meanwhile, Pratiksha, you may summarize.
Thank you so much, ma'am. And thank you so much, sir, for the time and the effort you have taken for the participants and for us.
Thank you.
The way we have delved deep into the session today and the kind of understanding that you have brought for us is incredible. We started the session off with arbitration agreement, delving deep into the terms of the arbitration agreement, the significance of agreement, as well as the significance of the terms of arbitration agreement. Then we also delved into other aspects, other important aspects of arbitration, and we ended the session with how are we supposed to resolve any dispute which arises with regards to arbitration as well as the contract. And last but not the least, you definitely dealt with some, I would say, tips with regards to advocacy.
I have to make it short. But I was supposed to talk more, but I know the time constraint. और जो बच्चे हैं वो भी they might be very tired now after hearing me up 1.5 hours. But next time, पक्का, I will give you some good tips.
Completely understands
Hmm.
your stance and your feelings on this. Being a professional and seasoned advocate in the field of arbitration and talking about arbitration definitely comes with its own interest and excitement when it comes to talking on the topic. So we are open for any questions, participants. If we have any question, you can raise your hand, type it down in the chat box.
I think the participants today are more even eager about the results that is to be declared. They have been waiting since yesterday. Just this responsibility is also in your hand to declare the results. I'll be sharing the screen. We have earlier the plan was to declare top four, but we understand that the teams have participated and they have like came so far in this journey, and we would like to definitely take as much as teams possible ahead. So we are going ahead with top 8 teams. But the twist is that after the written submission, which is of notice of arbitration, which is of response to notice of arbitration and rejoinder, there will be one another elimination, from which we'll be having the semi-finalists, which will sit in the oral rounds of arbitration. So today we have top 8 teams. I'll share my screen, sir, and I think the teams are more or less waiting more for this. Yeah, yes, sir. Yeah. So my screen is visible, I believe.
Yes, ma'am.
Okay. So there we go.
So the results are out.
Yes, sir.
So who are excited? They can raise hands.
First team to go is Christ University, Bangalore, Taac
Ah,
051.
Congratulations to Christ.
Yes. Second is 055 Asian Law Colleges.
Many congratulations, Asian.
Taac 056, it's HPNLE.
Wow, very good.
Then we have Taac 057, it is again HPNLE. Taac 058 is again HPNLE. So three
Wow,
teams from HPNLE. Yes, sir.
Himachal Pradesh National Law University. I would love to come to this place because they are fighting in between them only because three
Yes,
teams are. Wow. Sorry? Somebody said something. Okay.
I believe somebody. Okay. So we
Okay.
have still teams left. Again, we have 061. It's again from Christ University. Then we have 064. It's from Maharashtra National Law University, Nagpur. 061. It's Faculty of Law, University of Delhi. So these are the top 8 teams who are going to.
So many congratulations to the team. I hope all the very best for your future, for the future participation in the competition, and hopefully we will meet someday in the court, I believe. And if you have any questions, just let me know. Other then we can wind up sooner.
If there's any question, guys, we still have 1 minute. You can put it in the chat box. Students are writing nervous. Okay, now the results are declared. So no need to get nervous, Jasmine. It's all there. So thank you so much, sir. We'll be also opening a Google form after every session. We open one Google form to seek the queries because many a times the participants are hesitant in speaking up during the session. So they give their
Right.
queries in written form. I'll circulate the queries with you on email, and then we can have a written response.
Yes, you can connect me on email. Please share my
Yes.
email and other ways to connect also. And in case you have any specific queries, I am very happy to respond to that.
Yes.
Because I want law students, because now they are into arbitration, they are into mediation, and these are things we're going to help you in future. If you have any specific query, not the query from general query, see, which so any specific query you have, which really you think it's very important to have a session, I'm very happy to help you.
Sir, Kushal has one question. I think this would be the last thing. What trends are you seeing in India, sir, regarding institutional arbitration versus ad hoc arbitration?
I told you my experience. I will again repeat in front of you. So without taking any names, I have suggested my client, especially in the commercial contracts, that why don't we take DIAC, IAAC in the contract? In fact, I was sitting with the PSUs as well. I told them, if you have a problem in the ad hoc arbitration, which you think it is not good, then why don't you include in your contract? They say it's okay, but now the trust factor regarding the institutional arbitration has not developed in India. That's the problem. They develop the Singapore rules. They go to Singapore, they spend money, but they will not spend money in putting the contract regarding the IAC. So I'm trying to understand why. Then the reason is, in ad hoc arbitration they are more free because they say he is my nominee arbitrator. At least he is going to help us. But this does not happen. When the court appoints somebody, an arbitrator has to be independent and impartial. So institutional arbitration will generally grow. I think after 3-4 years we will have certain more precedent on that institutional arbitration, and thereafter it will pick up. So we have to wait for some time. As of now, you see a lot of retired Supreme Court justice are going for an ad hoc arbitration rather going for an institutional arbitration. So that's also a big point. Even I tell you a simple thing to all the candidates: read one judgment. The judgment is Singh Brothers. Singh Brothers judgment by Supreme Court by Justice Ravindran. And in that judgment, it is written, it has been seen that, after the post-retirement, they go for arbitration, lot of arbitrations. So that is why maybe shouldn't be saying this thing, but I have written an article on it. So it is in a public domain. But we have seen that ad hoc, they are preferring to ad hoc arbitration. But time is now that why can't we adopt Singapore culture? So most importantly, you have to have that culture first rather adopting that institutional arbitration. But trust me, give 5 years, you will see. Once you will graduate, you will start practicing, you will see that you will be doing some institutional arbitration for sure.
Yes, sir. Thank you for that. So there's another question. What common mistakes do the advocates do in what the advocates make in arbitral hearing?
That's very important. That's what I was telling you, because you know, you know, practically speaking, I have seen this not even in the arbitral tribunal, even in the courts also. If you're not prepared with your brief, because see, in Supreme Court and High Court, you have to argue on a limited point. But when it's come to the tribunal, you have lot of documents, especially when you will see you're going to assist your senior. I have filed 45,000 documents. 45,000 documents. A human cannot just, you will say, please tell me on page number so and so. That is a different thing. You have to figure it out. You have to say that, look, as per these issues, these are the documents, these are the communications. So you have to well prepared. That's why, people say who do arbitration, they should do arbitration only. They should not go for a court hearing. So this is the ADR. Once you are into ADR, you have to be an arbitration lawyers. That's the reason Arbitration Bar of India has also, came in force recently. And every time when I appear in the court, when I appear in the tribunal, they say, no, you are an arbitration lawyer. You don't have any liberty to go to the court at 10:30. You have to be here at 10 o'clock, 10:30. So, because why it is happening? Why he is saying? Because the question is, we cannot merge our practice. If you have to have an arbitration lawyer, especially in a dispute like energy, environment, interstate water dispute, any dispute, then you have to be very well versed with the documents, communications, what are the issues, what are the discovery application. I think these things are very important to conduct the hearing, nothing else.
Thank you, sir. So one last question we'll take, Khushi has. What are the key elements of a persuasive statement of claim or defense?
Yes. So, I will share with you a template also regarding the SOC? That's a very, very good question. I think she understood why SOC is very important. Why SOD is important. SOC, just like the notice I told you, the template, that's the reason how SOC has been drafted. First, you have to list out the contract part. First, you have to list out the party's name, how contract has been concluded. Then the dispute has to be segregated further claim wise. So suppose if you have claim number one regarding, for example, if I tell you regarding idling is something which you will see in the construction contract. Uh, Suppose there is a delay and your assets or your machineries are lying there and you cannot use in other projects. So therefore, idling. So claim one is idling. How idling has been created? You have to share the vouchers. You have to give the details just to prove your claims in contract in claim number one. So that is a one claim. So claim has to be backed by evidence. You can just not give an Excel sheet without any vouchers to make your claim. So that is why statement of claim is very important. All the document has to be annexed in accordance with your claim, which can justify before the tribunal. The tribunal cannot just say, okay, you have placed one document which is only saying that there has been idling without any evidences or without any vouchers. How can you show? So that is very important. This is how you have to draft every claim supported by the evidences.
Thank you so much, sir. That was it for the questions for now. I'll circulate the question any received on the Google form and then I'll share it.
Thank you. Thank you.
Thank you so much, sir. Thank you, everyone. We'll end the meeting here.